It is 6 o'clock. Let's call the meeting to order. We've just got one thing on the agenda tonight, the sex offender ordinance discussion. So just before I hand it over to you, Dave, this was something that I asked to bring up after seeing the issues that were in our neighbor to the north in Victoria. And they had a bunch of the community, come on in, how's it going? A bunch of the community members all riled up. And they kind of reacted and did an ordinance for sex offenders. So I met with Deb McMillan and kind of gotten her point of view, but I'd love to know, kind of officially from the lawyer, what we can and can't do.
Sure.
Which I think you've outlined in your memo pretty well, but.
Yeah, so about 100 cities have these on the books, and they're all very similar. Just to give kind of a high-level summary of what they look like, they're very simple. They define what a predatory offender is, and that's typically a level 3 sex offender. For those that are a little unfamiliar with how that works, is after somebody's released from prison, if you've committed a sex offense, you're given a risk assessment score, and it's between 1, 2, and 3. Obviously 1 and 2 are lower level in terms of the risk to reoffend, and level 3 is of course the highest. And so when level 3s enter back into the community, there are some requirements for law enforcement to notify people. So usually communities become aware of level 3 sex offenders if they are moving in, because there are requirements that law enforcement make that apparent to the community.
So they just have to notify for level 3, not level 1 or 2?
There are
different grade?
There are not requirements to notify the community of level 3. You can notify certain people. There are always a requirement that you notify victims of particular offenders, regardless of whether they are a 1, 2, or 3. So if you are the victim of somebody who's being released back into society.
Is home daycare part of that, where they could
sometimes, yeah. So it depends on where they're going to be living, and there is some discretion. I'm not super familiar with what law enforcement has to do. Okay. They have some discretion in terms of who they're going to notify and how they're going to do it. Like I said, a lot of times community meetings are held, and so that's where it becomes public information, and people get kind of vocal and they talk to their local politicians about these sorts of ordinances. A lot of times these ordinances are more reactive than proactive, which is very difficult for cities and the political component, because generally speaking, you can't tell somebody they can't live somewhere if they've already established a residence in your community. So these don't look back. They are not retroactively applied. And what I was trying to convey in the memo is that these are very difficult to defend in court. In fact, cities, to my knowledge, have never been successful in defending one of these things if they're challenged. None of them have been appealed, which means there's no Court of Appeals or Minnesota Supreme Court decision that is ruling law that says you absolutely cannot adopt these ordinances, which means cities can still technically adopt them, but my suggestion and advice to cities when it comes to these things is if you actually do get challenged on one of these, given the history of how they've done in district court, you're probably not going to succeed. And that mostly is due to the preemption issue. The state has a sex offender residency statute and program that is meant for reintroducing offenders back into society after they're released from prison. And what the district courts have said in all these cases is that is the only way that their residency is to be legislated. Cities don't have any authority to go above and beyond what the state does in that respect. So again, many cities still have these on the books, and they're not illegal per se, but they're really difficult to enforce and they're really difficult to defend. So I think that's important to know as you consider something like this, because push came to shove and you wanted to enforce your ordinance because a level 3 was going to be moving into your community within one of the artificial buffers that doesn't allow it under your ordinance. and they challenged it, you'd have a really difficult time succeeding in a lawsuit.
So can I jump in there?
Of course, yeah.
So several of the ordinances that cities have right now, they create buffers around what they feel are sensitive uses. So examples would be schools, daycares. Some cities have gone as far to say bus stops, which is kind of arbitrary and tricky because those things move. So what they say is you can't place a level 3 within 100, 200, 500 feet of those zones. So in Carver, things like Carver Elementary would get a big circle buffer on it, and Children of Tomorrow and in-home daycares. One of the things I struggle with the most is that it protects those people that live in those bubbles, but then there are people who live outside of those bubbles, and it's essentially saying that a sex offender could live in those areas. So it kind of creates an area that feels safe and unsafe based on what buffers you are and how close you live to those certain types of uses. So I think things like parks are also one that's considered. So some communities can buffer so many things that there's only pockets left, and think about being the person living in that pocket that's not close to anything, but where a level 3 offender could locate to should they choose. So it's an interesting dynamic that you can buffer those areas, but then you're essentially creating the areas that they can't live. And what does it feel like to be in the area where they can live versus the people who might live in Copper Hills, which is covered by Carver Elementary.
Yeah, so for example, one of the last ones of these ordinances that I was involved in and drafted was for the city of New Prague. And that one reads that a designated predatory offender cannot establish a residence within 1,500 feet of any school, park, library, place of worship that provides regular educational programs for children, dedicated vulnerable adult housing, because vulnerable adults are of course also considered part of that vulnerable population, or any other place where children are commonly known to regularly congregate, which is kind of a difficult thing to interpret, right? What does that mean? And anyone could say bus stops are like that. Now, there was a lot of discussion about that language. It's not uncommon, a few cities have that language, but I don't particularly love it because I think leaving room for interpretation like that is just a recipe for disaster when it comes to enforcing these things. And so to me that sort of language isn't great, but you kind of get the sense based on that language of where cities go with these ordinances.
So when you said New Prague recently, like months,
That was a couple of years ago. It was like 2017, I believe.
2017.
Mm-hmm. Maybe 18. I can't remember exactly when that was, but.
So this is exactly what I wanted to learn more about, the pros and cons about if we did something like this. And I've got to be honest, I think if you Google Apple Valley, I think it is, right, recently, and sex offender, you'll learn that they just paid out $70,000 to a John Doe who sued because of their ordinance. And the more I learn about these, and per council's advice, council's counsel, I guess, we can't defend this. So that said, it's my understanding that Senator Coleman is working on legislating at the state level the preemption issue that would let the cities do our own thing. It's my understanding, are you saying that that's kind of only half of the issue is preemption is the first thing that makes it undefendable, but then there's the other issue?
There are also constitutional issues, civil rights issues that I think that was the Apple Valley, the basis for the Apple Valley lawsuit was a civil rights claim.
Okay.
And there's at least one or two other cities in Minnesota that have been sued for civil rights violations, and those have also not done all that well.
So when you were saying like haven't done all that well, and then earlier when you said it would be difficult, and like another example, difficult.
Mm-hmm.
Other than like this dollar amount Apple Valley, do we have any idea like the number of hours it took to defend the dollar amount? Like
That's always.
no. And like that's
Does
it
always.
matter though? Do you have a threshold of $100,000? Do it, you know?
Well,
I do
If you can't win.
not looking at like what the actual not the actual like topic, but just from a high level, a risk assessment, where sometimes it's like, oh, what are we opening ourselves up to? So just from that perspective.
Well, and it's less
Yeah,
about
you know.
attorney's fees because, I mean, you have insurance. If you were sued, your league insurance would kick in and they would defend you in a lawsuit.
To a point.
To a point. Well, but the other thing is they don't pay damages, and some of these cities are having to
Okay.
pay pretty big damage awards and can be required to do that. I mean, that was the Apple Valley suit. I think that's settled for $70,000. I don't think there was any sort of a decision in that case. But the other thing to keep in mind is it's a policy decision because when a city adopts an ordinance, it's presumed to be valid, legal, and constitutional. The law presumes all ordinances to be okay. I mean, that's why cities, I always tell cities, if you can dream it, you can do it when it comes to ordinances until somebody tells you you can't, because we do have that in our favor. But the problem is that the track record for these ordinances is so poor, and it really is going to, I think, in my opinion, it's going to require action with the legislature about this, because the preemption issue is huge. I mean, that's a huge hurdle to overcome with one of these ordinances if you're going to defend it. Again, there hasn't been, cities have not appealed these decisions because they don't want to create bad law. Because the city of Carver does not have to follow any district court decision from another community. What you would have to follow is a Court of Appeals decision that's published, or of course a Minnesota Supreme Court decision. And none of the cities that have lost these lawsuits at the district court level have appealed them. And so, that's why I say there's no precedential case law out there that says you can't do this. But again, the writing is on the wall that if you were asked to defend or required to defend an ordinance like this, probably wouldn't go well. And I say that because there are arguments to make that cities can do it, and that's why we do it. That's why cities are still adopting these ordinances and still have them on the books, because there are legal arguments you can make. I say probably, and would have a difficult time, because there's never ever 100% when it comes to how the outcome will be if you were to have to defend one of these things, but it's pretty unlikely, given where these cases have gone, that you would be able to prevail in defending yourself in a lawsuit like this if you had an ordinance on the books.
We have nothing right now. Do you know what the state's limitations are on a level 3-6 offender? Level 3-6 offender.
I don't have, I have some materials that I had prepared just to sort of use in case these sorts of questions came up. It's pretty convoluted.
Okay.
And it's all handled at the law enforcement level. For level 3s, you're saying?
Yeah, that's the worst, right?
Mm-hmm. So typically, for level 3 offenders, the local law enforcement agency must disclose the information about the person's release to the people and entities who feel bad that I'm reading this off of
You're fine.
a cheat sheet, but people who have requested disclosures when an offender is released. There are also agencies and groups that a person is likely to encounter. So for example, staff members of public and private educational institutions or daycare establishments. Those folks have to be disclosed information when a level 3 is released.
Is there a distance limitation to that?
I'm not sure.
Okay.
I'm not sure. And then there's a and I can certainly prepare some better answers to these kind of follow-up questions, because all that stuff kind of happens behind the scenes. I as a city attorney, don't see it ever.
Yeah.
And it's really handled, like I say, by local law enforcement. And so I feel bad trying to answer some of those questions on the fly. I want to make sure if I'm giving you answers, they're accurate ones.
Yeah.
I don't want
No, that's fair, thank you. And I think that was part of the rub with the situation in Victoria, is that it happened real behind the scenes and surprised a lot of folks, including local law enforcement, with some last minute moving and issues there, although I don't know just enough about that situation up there to be dangerous. I am meeting with Senator Coleman tomorrow, so I'm inclined to say I want to hear what she's working on at the state level, because she represents Victoria as well. So apparently she's been working on this since this blew up in Victoria, which was earlier this summer. I'm having a hard time being comfortable with enacting an ordinance that our attorney tells us is really, really, really hard to defend. So
Something else to think about in the Victoria situation is that they had an ordinance when this happened. It was probably 2016.
16 or 17, I think.
When that ordinance was adopted, so they had something on their books, and the level 3 offender continues to live in their community. So an example to say the buffers, he was outside of those buffer areas, so it's one of those spots that, yes, this was buffered and this was buffered, but there are places in a community, so you can't.
I believe the reason that he was not covered by the ordinance, I think, is that he was moving in with his parents.
You're right.
And many cities have that as an exception. If you're living with your parents or grandparents, the ordinance does not apply to you. And I think there's some public policy rationale behind that. It's, maybe you don't have the means to live anywhere else, so your parents are providing you support, or, you also have additional support of family. There are some, and I'm certainly not trying to play policymaker, that's not my role, but there is some pretty compelling information and studies out there about, I think 95% of all sex offenses are committed by first-time offenders, and I think 93% are committed against people that they have intimate knowledge or relationships with and about. So, that would suggest that ordinances like this really don't have all that much of an impact. Not to say that there aren't those other 7 or 5% of situations that an ordinance could certainly protect somebody in a situation, but I would just urge the council, if you're considering this sort of thing, to make sure you look at the different resources that are out there about the policy reasons for it. I didn't mean to jump in, Mayor, and share that, because I know you were talking about your meeting with the senator, but there is some interesting information out there that it wouldn't hurt to take a look at. Again, I'm not going to pretend like I am the one making policy in Carver, but I think there's a lot of information out there that can be helpful when you think about this. So,
How many level 3 sex offenders get released a year?
no idea.
Approximately 403 registrants subject to broad public disclosure are living in Minnesota communities as of January 2020. So
A total of 403.
correct.
Out of how many years?
Couldn't tell you.
So it's a small percentage of level 3 sex offenders that get released.
Of all registrants who have been assigned risk levels, approximately 56% are level 1. So a group you wouldn't hear about. 29 are level 2. 15 are level 3.
Basically what I'm hearing from council is be careful about enacting an ordinance that, I can't defend. For the most part. Are we creating an issue? Are we creating something that people are going to open up to? Well, there's going to be conversations about it. Absolutely. I don't mind having the conversation. But are we creating something that doesn't exist?
solving for a problem that doesn't exist.
Correct.
Yeah. Well, and it doesn't exist in our community, but I think.
And it's basically what our attorney is telling us is most of these ordinances are pretty much indefensible. Or unless you want to start opening up your checkbook and spending a lot of money.
And that's the thing. So I think the optics of we've got an ordinance, we'll be safe, it'll be fine. When it comes down to it, it's not defendable. And I think the optics of having to write a check, like you said, to a sex offender.
Not just to the sex offender, but also to the attorneys to fight the
Yeah,
battle.
right.
I mean,
That
that's,
I'm not comfortable with, so.
So,
not that we don't mind paying our attorneys, but
so I was in Victoria when that ordinance was adopted, and we had some intense public hearings from people who lived outside of the buffers, who then were saying things like, why isn't my home safe then? I need a buffer, I'll take a bus stop, put a bus stop in front of my house. And those are really challenging conversations to say, like, you don't have one of these sensitive issues, but it was hard to say that to people who were saying, I have 4 young kids and there's 35 kids in the neighborhood and we're outside of the buffer, and why do they get to be in the buffer? So just from the human side of it, that was really challenging.
Lori, thoughts?
The only thing I really like is that we don't have to be reactive. That we're having a discussion now and we can look at what the options are. But with that, there aren't many options. I feel like as far as how an ordinance could be worded that would have some teeth in it, that we could stand behind. So I'm comfortable not having an ordinance because I haven't seen anything yet that I would support. So that's where I'm at. I would love to continue to revisit, and I think just with the world's news and just our local government, we'll hear things, maybe in less than a year, something will come up that we can align to and write an ordinance that we feel has a little more teeth in it as far as defending our financial assets. So that's where I stand.
Okay. So I hear you saying that you would agree to table this
Correct.
into perpetuity or for the time being. And that's what I hear you saying too. Glenn.
yes. Question, so the state sets the parameters for basically Minnesota, correct?
Correct, yeah, and they all have to, all sex offenders have to register.
Right.
And they have to, I think, some of the level 3s even twice a year, but you have to update where you're living. If you move, you have to immediately notify law enforcement agencies in the community.
That you're moving to and the one that you're leaving,
I
correct?
believe the one you're leaving as well, because you're updating your residency.
Correct.
So, and it's a felony to violate the registration requirements. So it's a very serious offense for a sex offender to not report, where that person is living and make sure they're up to date on all the registration. But I guess I just mean it's pretty closely. They keep tabs on that pretty closely. Law enforcement and folks that are handling all the sex offender registration.
So basically, we're leaving it up to the state, and you're gonna meet with the Senator Coleman and see if there's gonna be new ordinances, what they would.
No, what she's working on is the preemption thing, so taking away the preemption so that it would be more up to the cities.
Got it.
That wouldn't, that's kind of the head side of the coin. That wouldn't help us with the tail side of the coin, which is the civil rights and all that kind of stuff that council was
Or
mentioning.
the civil
but-
liberties.
Yeah.
And the constitutionality of having the freedom to live where you wanna live.
Exactly. So I hear you saying that you're okay with not setting the wheels in motion on this.
Correct. I don't wanna create anything that we can't defend anyway. But, see what the senator has to say.
Just made my list for her, and I will report back at the next meeting. Thank you. Let's see, with that, any council requests? Hearing none, I would entertain a motion to adjourn.
I'll make a motion to adjourn.
I'll second.
A motion by Councilmember Henry and a second by Councilmember Sarah. All those in favor say aye.
Aye.
Opposed, same sign. Motion passes.
How you doing, Mike?